Hi, thank you for joining us. I'm Kyle Dana, Senior Vice President of Retirement and Investment Solutions with AG Financial. Today I have joining us Dr. Richard Hammar, the Chief Legal Counsel for the Assemblies of God, as well as author of Church Law and Tax Report. Thank you for joining us today, Dr. Hammar. Today we're going to be talking about a rather hot topic that's got a lot of attention over the last few weeks. We're going to be talking about the recent court case regarding the minister's housing allowance. And just to provide a little bit of background for those of you that are tuning in that may not have heard the news, back on November 22nd, on Friday, there was a federal district court judge, Barbara Crabb, from the District Court of the Western District of Wisconsin, that struck down the ministerial housing allowance as an unconstitutional preference for religion. And this ruling was in response to a lawsuit that was brought about by the Freedom from the Religion Foundation, which was challenging the constitutionality of the housing allowance and the parsonage exclusion. So today we're going to talk to Dr. Hammar and get his expert opinion, as we have received literally hundreds of different emails in response to this, so we want to be sure we get your questions answered. During our live feed today, we'll be receiving live questions as well, so if you have a question as we're talking that does not get answered, please submit your question and we'll be sure to try to ask that within the live stream today. Dr. Hammar, why don't we start by going back a little bit and maybe giving a little bit of background on the housing allowance in general, and then as we move in from that, kind of talk about this recent court case and what was the basis for the ruling.
Okay. Well, the housing allowance originated in the Internal Revenue Code of 1954, but prior to that, in 1921, in one of the very first internal revenue laws after the 16th Amendment was enacted, the parsonage that many churches back then owned as the residence for their pastor, the rental value of the parsonage was deemed to be a tax-free fringe benefit for income tax reporting as a result of the 1921 Revenue Act. Now, keep in mind, that was very significant because when you look at 1921, many churches had parsonages that had been built many years before the automobile era. Just think how different it was before the advent of the automobile. Churches typically had to have a parsonage on their premises to accommodate their pastor. The automobile had so many changes and ramifications on our culture, and one of them was clergy now could live 10 miles from church and just drive to church each day. And so many churches did that. They moved out of the parsonage and they purchased their own home, and not to, in addition, because there were tax benefits for doing so. And so they were living in homes 5 or 10 minutes away from the church that didn't qualify as parsonages. So you had this disparity. Clergy that lived in church-provided parsonages had tax-free housing, but those that moved out of the parsonage and lived in their own home that they were purchasing, that they owned, they did not have tax-free housing. So this was seen as a disparity, as an inequity, and as a result, in the massive 1954 Internal Revenue Code, which was a major rewrite of our federal tax law, one of the provisions in that law, out of thousands, was to recognize an entirely new concept, and that was the housing allowance. And what that meant was that for those growing number of ministers that had moved out of a parsonage and were living in their own home, the amount of their church compensation that their church designated in advance as a housing allowance was not taxable for income tax purposes to the extent it was used to pay for housing expenses. So that more or less equalized the treatment between ministers that lived in parsonages and ministers that moved out of the parsonage and lived in their own home. And so that was 1954, 58 years ago, something like 59, almost 60 years ago that this happened. And it essentially went unchallenged. There were virtually no constitutional challenges to this housing allowance, nor to the parsonage exclusion until recent years. But as you pointed out, Kyle, a federal district court in Wisconsin recently ruled that the housing allowance was an unconstitutional preference for religion in violation of the non-establishment of religion clause of the First Amendment to the Constitution.
So what I've heard many of our people talking about is that there's an argument that exists that housing allowance is not just for ministers. There are other groups that that benefit from a housing allowance. So in this particular case, will those other groups also be affected? Is this going to be just for ministers because of the religion?
It would be. There are other groups of taxpayers that get tax-free housing, and the court referred to them. The government's brief in support of the housing allowance referred to them. And the two main categories are the military. Military personnel get a housing allowance, and State Department employees that live in other countries get the benefit of a housing allowance. But the argument was made by the Department of Justice, the government that's tasked with the responsibility of defending the constitutionality of federal laws, and they made that argument, which I believe is a strong argument. It's not conclusive, but the Wisconsin court rejected it and simply said it's not enough to point to a small number of secular groups. On the other hand, the court referred to a 1989 ruling by the United States Supreme Court that looked at the constitutionality of a Texas law that exempted from sales tax sales of periodicals and books by churches, by religious organizations. And the Supreme Court struck that down as unconstitutional because it wasn't a broad enough exemption. And they contrasted that ruling from a 1970 Supreme Court ruling in which the Supreme Court, by an 8-to-1 vote, upheld the constitutionality of a New York law exempting religious property from the property tax. So, but in that case, back in 1970, the reason that the Supreme Court validated exemptions for church property from property tax was that the exemption statute was a large basket that included all kinds of charitable organizations, public schools, museums, libraries, hospitals, churches. So as long as religion, churches, religious organizations are in a large basket that includes many other non-religious charities, that is constitutionally permissible. But if the only thing in that basket is clergy, in the case of the housing allowance, basically, or churches, as in the case of the Texas sales tax exemption, that's constitutionally suspect. And you're right. The basket with regard to the housing allowance does have a few other taxpayers in it. It's not just ministers. It's also State Department employees and military. And believe me, that's a pretty substantial number of taxpayers. And that will be the argument on appeal. And we might talk about that. Is this over? Or is this case subject to appeal?
Absolutely.
And the answer is yes, it can be. For this type of ruling in which the government or a federal agency is a party, as is true with the housing allowance challenge, the appeals period is 60 days. So the government has 60 days. I've not seen what their decision is. I'm sure they're still in a decision-making process. I would be surprised if the case is not appealed. If it is appealed, it goes to the Seventh Circuit United States Court of Appeals, which sits in Chicago. They have jurisdiction over Illinois, Indiana, and Wisconsin. And that court could do basically one of two things. There are other options, but the two main options would be affirm the Wisconsin court's ruling, or it could reverse it and say, no, we think there is a constitutional, we do not believe there's a constitutional infirmity here. We believe the housing allowance is constitutionally valid. And if so, this will not be the first time that Judge Crabb had a ruling reversed, because a few years ago, she ruled, by the way, she was appointed by President Carter back in the late 70s. She ruled a few years ago that the National Day of Prayer was unconstitutional. And that was reversed by a unanimous 3-judge panel of the Seventh Circuit Court of Appeals, 3-0. So now the Seventh Circuit is not I wouldn't call it a conservative court, but I would call it a moderate court, which means I think we're going to be likely to get a more objective ruling, not a knee-jerk reaction. I don't like religion, so we're going to strike this down as unconstitutional. And I will not be surprised if the Seventh Circuit reverses her ruling. It's also important to point out that she stayed the enforcement of her ruling, meaning she postponed her ruling until all appeals were exhausted. So if the Seventh Circuit, if the case is appealed, you know, how long does it take for the Seventh Circuit to put this on its calendar, hear oral arguments, have the parties brief their sides? I mean, this would take at least a year, possibly up to 2 years, probably closer to 1. But so all that time, housing allowances are permissible. So just in light of this case, you don't stop declaring housing allowances, churches. You know, continue designating housing allowances. And by the way, a decision by a Wisconsin federal district court is not binding anywhere outside of that district. If the Seventh Circuit affirms, then it becomes binding in every church in Wisconsin, Indiana, and Illinois. It's not binding in 47 other states, unless the United States Supreme Court takes it on appeal and issues a ruling one way or the other. Then it becomes a national precedent. But the Supreme Court, last year, I think they took 80 out of 10,000 appeals. So it's about 0.8%. The likelihood of them taking a case like this, extremely remote. So those are some of the realities here with regard to the appeal. Now, let me just conclude with this point, and that is that the IRS, and this sometimes happens when sections of the tax code, you know, it's 85,000 pages long, so it's not unusual for a federal court to say one section is unconstitutional. When they do that, the IRS, even though that's only binding in that federal district or the circuit if it's on appeal, the IRS has the authority, has the, may I say, the discretion to apply that ruling in all 50 states. So look at this. If the case is appealed and the Seventh Circuit affirms the ruling, it's binding in those 3 states of Indiana, Wisconsin, and Illinois. But the IRS has the discretion to apply it nationwide in the interest of uniformity and tax administration. So you ask yourself this: well, what kind of situation would we be in if ministers in those 3 states can't claim a housing allowance, but all 47 states they can? Think of the chaos in the Ministers' Benefit Association trying to grant housing allowances to retired clergy, just to use that one example. Or what about a pastor that's in Illinois and makes a change in the middle of the year and moves to Iowa, where the law wouldn't necessarily apply? So there would be absolute confusion. And that's why it's not uncommon for the IRS, as a matter of discretion and uniformity and tax management, to say we're going to apply this as a matter of discretion in all 50 states. We're way too soon to know what's going to happen there.
I think that's great information. Just to reiterate a few of the points you just made, though, Dr. Hammar, that I know that we're getting a lot of questions on, is, as you said, currently, despite the ruling, at the current moment in time, the ministers in those 3 states, Wisconsin, Indiana, and Illinois, can still declare housing allowance.
Well, the church can.
The church can still do it.
And the minister can claim it.
And
yes.
Then until the appeals process has ended and a verdict, then that's when it would make a determination on whether or not those 3 states would be impacted by that. And in your expert opinion, you feel it unlikely to go to the Supreme Court.
I do. Just look at the odds. Basically 0.7, 0.8% of all cases are accepted by the Supreme Court. They're just overwhelmed with it. Does this case rise to the level of the 80 cases out of 10,000 that it would take? I find that hard to believe.
Now, you mentioned in there, you talked about Ministers' Benefit Association. For those that are watching, and many people were not aware of this, but the housing allowance is not just for currently employed ministers. We have several of our retired ministers that are participating in their denominational retirement plan, their 403B through MBA. And as one of the many benefits of that retirement plan, retired ministers can declare a portion of their distributions as a tax-free housing allowance. So I know that I have been getting some contact from our older retired ministers who are asking, this ruling, if it did stand, would that also impact their 403B payouts in those 3 states?
Yes, it would. And it could be in all 50 states if the IRS chooses to enforce it or implement, follow it in all 50 states, which is a distinct possibility, even though it's not required to. That's going to gut ministers. Believe me, this is going to have significant financial impact on tens of thousands, hundreds of thousands of ministers in this country that purchased homes in reliance on the housing allowance. And now to have the rug jerked out from under them, it's unthinkable, it's unfair, it's unreasonable. And after 60 years, why did it take us 60 years to figure out the housing allowance was unconstitutional? What does that say? Does that say something about the law or the judge? And, you know, Justice Oliver Wendell Holmes, a very famous Supreme Court justice in this country in the early 19th century, said, not lightly to be cast aside are the verdicts of quiescent years. In other words, you know, if you have 60 years of unbroken implementation of a housing allowance with nobody challenging its constitutionality, and all of a sudden a challenge comes forth, I mean, shouldn't the fact that it's gone unchallenged for 60 years carry some weight? And I think absolutely it should. And I think that's going to be part of the process before the Seventh Circuit, if it gets that high, that something that's been the law, something that has resulted in settled expectations for hundreds of thousands of clergy that have relied on it for 6 decades, should that not be entitled to something? And I think it should be, in terms of interpreting a very ambiguous provision in the Constitution that the federal government shall not establish a religion. How is this establishing a religion to give ministers a housing allowance? And by the way, there's another argument that will be made on appeal, and that is the standing argument. And standing is a technical requirement for all federal cases, which means that the plaintiff must have some direct injury in order to bring or prosecute a case in federal court. And when you get into the issue of taxpayer standing, where taxpayers are trying to challenge provisions of the tax code, it becomes more complicated. And that's why an earlier version of this case that was filed 4 or 5 years ago in California was dismissed by the Freedom from Religion Foundation, because it was obvious they didn't have taxpayer standing. But in the Wisconsin case, they changed their tactics, and they said, well, we're going to have some of the officers of our organization apply for housing allowances. They're not entitled to them. So now they're saying we have direct injury. Our officers were not able to get a housing allowance, so we don't have to rely on this more esoteric taxpayer standing concept. But nevertheless, the issue of standing is a technical issue, but it's another potential basis for reversing this case on appeal.
In context of all this, is there anything that Congress could do to reverse it?
Absolutely not, because this is a constitutional interpretation. And let me say, there is one thing Congress could do, and I call it the nuclear option. And that is, Congress has the authority to define the jurisdiction and the authority of all federal courts. And this is a power that it's not used enough, in my opinion. I mean, I don't know that it's ever been used in our nation's history. But Congress would have the authority to draft a statute saying, we are hereby depriving the federal courts of jurisdiction to review challenges to the housing allowance. They could do that, and they would be depriving the federal courts of jurisdiction to review housing allowance constitutionality challenges. I don't see that happening. So short of that, there's really nothing that Congress can do to overcome directly a constitutional interpretation.
Now, earlier on, Rich, you were talking about the difference between the parsonage, which predominantly, when this started, was mostly parsonage allowances, to the evolution of the housing allowance. However, I do know that we still work with some ministers that are doing the parsonage allowance. I had read in your paper that the Freedom from Religion Foundation had initially tried to attack both the housing allowance provision as well as the parsonage allowance, but narrowed their focus to simply the housing allowance. And do you feel then that parsonage allowance, although a smaller group of people, that the parsonage allowance, if the courts upheld, that would still be at risk? Would we see a lot more churches in those 3 states move back to a parsonage solution to get around the ruling?
Well, the Freedom from Religion Foundation did narrow its attack, which included parsonage exclusion and housing allowance. As the case progressed, they focused entirely on the housing allowance. And I think there were many reasons for that. Number one, their executive officers didn't have parsonages, so they really didn't have direct standing to attack that. That would be number one. And number two, there's far more substantial grounds to uphold the constitutionality of the parsonage, because that basket is much bigger than clergy. You know, we've talked about the housing allowance. Yeah, there's a few more people in that basket, but when you're looking at parsonages, there's a lot of people in that basket because Section 117 of the tax code, or 119, provides that housing provided for the convenience of the employer is a tax-free fringe benefit in calculated income taxes. And so that any employer, secular, religious, nonprofit, charitable, any employer could potentially benefit from that exclusion. And the parsonage allowance is often seen as an outgrowth or related to that particular exclusion. And so I think the constitutional challenge to the parsonage allowance is a lot weaker. And so I think that's right. A lot of churches historically had parsonages. Even though the pastors moved out, they still have them. Oftentimes they just rent them to somebody in the community. But it could be, in some cases, that ministers may decide, well, maybe I'd be better off moving back into the parsonage. It's not going to cost the church anything, and I'm going to get tax-free housing, the equivalent, essentially, of what the housing allowance provided me. But let's wait and see. It's too premature now. Let's see what the courts do with this. And who knows? The Seventh Circuit, I think it's at least a 50-50 shot, may reverse that Wisconsin court, and it's going to render this issue moot. But the Freedom from Religion Foundation, they could still file another challenge in some other district court, forum shop. But it becomes increasingly difficult for it to prevail as they have negative precedent behind them.
Now, ministers are afforded several different tax benefits, the housing allowance obviously being one that has gotten most of the attention lately and is a significant benefit for most ministers. Is there precedent based on this ruling for other ministerial tax benefits to be voided in the future?
Yes, the tax code, our 85,000-page tax code, has, it has a number of provisions that pertain to ministers. And they're like the four big ones are eligibility for the housing allowance or parsonage exclusion, number one. Number two, your income is exempt from income tax withholding. Number three, you are self-employed for Social Security with respect to your ministerial services. And number four, you potentially have eligibility to become exempt from self-employment taxes. Now, the court in Wisconsin did allude to the fact that ministers have the right to opt out of Social Security. But Judge Crabb said, well, that's because that exemption is only available to the extent ministers have a religious objection to participating in Social Security. So that gets back to the First Amendment freedom of religion clause. So you could tell the judge didn't have to rule on that question, but she was clearly I think almost acknowledging that would be the outcome of that case, that particular exemption, these other special rules that apply to clergy, they're not constitutionally infirm. Number one, they don't provide any benefits, really. And number two, there may be a constitutional or religious basis. So under the freedom of religion clause, they would be constitutional. So I don't think those other special provisions, many of them are revenue neutral, are going to have any impact on clergy.
What do you feel that churches or ministers can do to minimize the impact if this decision is upheld?
Well, number one, let's wait and see what happens. Let's see if there's an appeal within 60 days. I believe there will be. You have no idea the influence religious organizations have in Congress. Do you know that in 2002, there were efforts by the Freedom from Religion Foundation and others to challenge the constitutionality of the housing allowance? And in order to stave off that challenge, Congress passed what was known as the Clergy Housing Allowance Act of 2002 within about 3 days by a unanimous vote of both houses of Congress. Now think about what I just said. A unanimous vote by both houses of Congress. Couldn't you imagine Congress today voting unanimously in 3 days on anything? Can you think of a single example where that might happen? But they did. And what does that indicate? The power, the lobbying force of religion in this country. So I don't want to underestimate or diminish or minimize in any way the legislative power that religion would have. That's going to come to play here if the federal government waffles on this. Well, we don't know if we want to appeal this or not. You're going to see, I think, major religious organizations step to the plate and say, hey, listen, this is going to be appealed. And, but that's about all they can do. Then it's in the hands of the courts to decide. And if the Seventh Circuit does affirm the Wisconsin, the Wisconsin District Court, and the IRS decides we're going to start implementing this nationwide, then it becomes more difficult. What can churches and ministers do to blunt the impact of this? Well, like I said, number one, you got to be aware of what these developments are. Number two, remember what we said, that the parsonage exclusion is still valid. The rental value of a parsonage provided, of a church-owned parsonage provided to a minister on a rent-free basis, that is a non-taxable fringe benefit. It was not rendered unconstitutional by this Wisconsin ruling. It may be. The Freedom from Religion Foundation, as I said before, began its assault on that benefit as well as the housing allowance. So they may well come back at some future date and attack that as well. We'll just have to see. But other than that, what can the church do? You know, increase the compensation somewhat of its pastor to assist with those mortgage payments that all of a sudden are going to become, you're going to have less income to pay your housing expenses with. And that's going to be a problem. And then one idea that I mentioned, I'm not advocating this, is eliminating the mandatory self-employed status of clergy for Social Security. There's no basis for that rule. And treat ministers as employees for both income tax and Social Security. If you did that, you would slash ministers' Social Security tax in half, because they wouldn't pay the full 15.3% self-employment tax. They'd pay 7.65%, and the church would pay the other 7.65%, just like they do now. And it is true that and incidentally, that would, in most cases, that would more than offset the hit you're going to take by losing the housing allowance. The Social Security adjustment, that's going to be a greater financial, so this would end up being a financial blessing, this ruling. I think Congress would be inclined to do this because there's no basis for this rule that ministers are always self-employed for Social Security. And Congress would view this, hey, this is a way to appease our minister constituents. But so that's a real possibility. And you say, well, that's just going to, the benefit to the clergy is going to come at the cost of the church, you know, having to pay half of the FICA tax for the minister. But just remember, according to surveys I've conducted, well over half of churches in this country already pay either half or all of the self-employment tax of ministers. So it's not a big deal. And there's a big difference between voluntarily paying half a minister's self-employment tax and you paying the employer's share of FICA tax, because in the latter case, that's a tax-free fringe benefit, not in the former. So those are some of the, and also for higher paid clergy, remember that the Social Security component of FICA tax only applies to income up to $117,000. So those are some of the things on the table that could be done to more or less blunt the impact of this ruling.
I want to take a few minutes and go to some of the questions that are coming in through the live feed here, Dr. Hammar. One of the questions here regarding the appeals comments that you made, the appeal process, it's a two-part question. The first was, who must make the appeal? And the second part of that was, can we do anything? And I'm assuming when they say we, meaning pastors, our fellowship, ministers in those states, can they do anything to encourage the appeal?
Citizens can't, ministers can't appeal this. The decision to appeal is made by the Department of Justice, because the federal government, through the Justice Department, is the defender of federal legislation. And so the question is, will they decide to appeal? I don't know the answer to that question. I don't think they've made a decision yet. They got 60 days to do it. So we're talking about mid to late January before they would have to make that decision. So it's something I'm monitoring. Certainly by the end of December, and you know, we're in the holiday season now. By the end of December, I think we should know a lot more than we do now. But if it looks like they're waffling and maybe not going to appeal, I think you're going to see a lot of major religious organizations step up to the plate, like they did, you remember, in 2002, and resulting in the unanimous vote of both houses of Congress in about 3 days' time to amend the housing allowance to make it constitutional.
Great. This is an interesting question. If a pastor of a church in Indiana and you live on the border of the state of Michigan and the law changes, could you in essence move to Michigan on the other side of the state and continue to receive the housing allowance, or is it about the church that the state is in?
Well, that's you see, this illustrates the whole point of let's say the Seventh Circuit Court of Appeals affirms the Wisconsin ruling, then it becomes binding in Indiana, Illinois, and Wisconsin. The IRS has the discretion to apply it in all 50 states for this very reason. Is this what we want? Right. People moving across the state bound? Oh, look, I can avoid this issue. And you may have pastors living 100 miles into Michigan or Iowa or someplace to avoid this rule. It's unthinkable that the IRS is going to. So I would say there's a good but not definite likelihood that the ruling would be, by the IRS, would be applied everywhere.
It would be applied everywhere. Another question along the similar lines, but if this is affirmed in the middle of a tax year, such as 2014, will that mean that I can't take the allowance in 2014, or would it not apply or go into effect until the tax year 2015?
We don't know, but we do know this. You need to have the housing allowance designated, and we'll worry about that later. Probably what will happen is the Seventh Circuit Appeals Court in Chicago, when they issue a ruling, if they affirm, if they reverse it, happy days are here again. But if they affirm the Wisconsin court ruling, then, yeah, that's, in their opinion, they likely will give guidance as to what is the effect. What does this do for housing allowances designated for 2014? I think we'll get clarification from the court itself.
Now, once the court makes their decision on that, could you find that Wisconsin has a different decision, or Indiana or Illinois, in the sense of it's immediate, and one other state may say it won't take effect until the next
state has nothing to do with this. This is purely a matter of federal law and whether the IRS is going to enforce it everywhere.
Fascinating. Well, Dr. Hammar, that wraps up a lot of the questions that are coming in, but I have one last question for you.
Yes.
The question I think that's on everybody's mind that I get asked, in your expert opinion, what is the future of ministers' housing allowance? So even despite what happens here, as we look forward 10, 15, 20 years, as our younger ministers are thinking about the future, what is the future of it, in your opinion?
I think twofold. Number one, I think the parsonage exclusion will remain intact. So I think churches need to give that some thought. You know, especially church plants, your young, newer churches, if you want to provide tax-free housing, it's a wonderful benefit. You know, for you to, and this is a very significant benefit in some high-cost areas like Boston or San Francisco area, where housing is so exorbitant. Ministers can't afford a house. So many churches purchase a home to provide housing for their minister. That is an unbelievable fringe benefit to have that as a tax-free benefit. So I think, and as I said, I think the constitutional defense for the parsonage exclusion is much stronger than for the housing allowance. And the second part of my response would be, with regard to the housing allowance, I would say it's a toss-up. It's about a 50-50, in my opinion, whether the Seventh Circuit Court of Appeals is going to affirm or reverse the Wisconsin court. I think there are significant arguments in favor of the constitutionality. There's no doubt how I'd rule if I was on the Seventh Circuit. I would rule that the housing allowance is constitutional for many of the arguments we've outlined today. But these are different judges than me. They view things quite differently, and so that makes it very difficult to say what they're going to do. But I'd put it at about a 50-50 on that.
Well, thank you so much, Dr. Hammar, for one, taking the time to be here today to educate our viewers on this topic, and secondly, for everything that you do for our fellowship, as well as multiple other fellowships that utilize your resources. We are greatly appreciative for everything that you do. And if I'm a minister, I'm going to be anxiously awaiting to see what unfolds with the appeal process. So we will be in touch with you, as I'm sure you'll be keeping us up to date on the appeals process. And I would also just say that if you ever would like to get additional resources or information about not only the housing allowance, but other resources that are available to your churches and ministries, feel free to log on to our website at agfinancial.org, and we'll be happy to update you, and contact us if you have any questions. And again, thank you for taking the time to join us today. We hope this was beneficial to you.